Madam, let me start first with the need for the powers, which many in this bill, which many have queried. Madam, the riot in Little India was the most serious public order incident in Singapore in over 4 decades. And lest we forget, it occurred just over 9 weeks ago. There was 1 fatality, several injuries, and extensive damage to property. It might seem distant, even remote, from the calm of this chamber, but it remains a stark reality for the residents and stakeholders in Little India, our officers who were involved in the incident and who continue their duties there, and indeed for many Singaporeans and foreign workers. And Ms. Denise Pua has portrayed this vividly. In the immediate aftermath of this incident, the government and our enforcement agencies took several steps to address various factors that could have contributed or aggravated the incident. Indeed, many in this House have welcomed those initial responses. We needed specific powers under the POPA and other legislation to implement those measures. And that need remains valid today. There is a heightened security environment in Little India. We continue to have large gatherings in the area on weekends and public holidays. Residents and stakeholders remain concerned that an untoward incident may recur. So we need specific and limited set of powers under this Public Order Additional Temporary Measures Bill to maintain public order and calm effectively in Little India. So several members, too many for me to list, I hope, but I think you know who you are, have said, why can't we just continue with the present arrangement? In other words, just continue relying on the Public Order Preservation Act, POPA. Madam, many members have advocated that we adopt a proportionate and appropriate response to the situation in Little India. And we agree fully. And indeed, that has been the key reason for this bill. So it's ironic that some members have taken issue with the powers in this bill, which are limited and significantly reduced compared to those already available today under the POPA. The powers under POPA are extensive, some would say even draconian, and it is a law conceived to deal with a far graver set of circumstances, such as state of emergency. It has powers, as I said earlier, to impose curfews and even use lethal force. This is not a case of moving a bill because we have insufficient powers, as Mr. Chen has suggested. It is a case where the powers are grossly disproportionate to the current situation in Little India, especially as the situation has stabilized and the focus is now on maintaining public order. Therefore, the status quo of relying on the powers under the POPA is neither necessary nor desirable. Indeed, Madam, the logic offered by several members is quite elusive, because it is that we welcome the measures that have been taken. We are concerned that you exercise powers and have powers with proportionality. We want to make sure that there are adequate safeguards. Well, why don't you just continue using the Public Order Preservation Act, which has got extensive powers, and it will not invite this level of scrutiny? If you are prepared to accord the authorities the powers under the POPA, then why are you reluctant to accord the powers which are significantly reduced compared to the POPA as reflected in the bill? If you are concerned about safeguards in the exercise of power that is enumerated in this bill, then why are you not even more exercised by that concern in the context of the powers under Public Order Preservation Act? And if you're concerned that this bill will somehow tarnish the image of Little India, then what do you think the proclamation of a state of danger in Little India every week do? Other members have suggested, why don't we just defer the bill to after the COI? And the suggestion here is that the COI will finish its work in a few months, and then we can just get on with whatever we need to do. As Mr. Nispoa and others have noted, the COI will take some time to finish its work, and it's been given 6 months. And thereafter, whatever the recommendations, they have to be deliberated upon, and then appropriate measures put in place. So there is considerable time still ahead. And who will be answerable to Singaporeans and to the residents in Little India if another incident were to occur? It is incumbent on the government and our agencies to take reasonable steps and measures to ensure that such an incident does not recur. This bill provides for calibrated powers, far less than in POPA, to continue with the measures to maintain law and order in Little India. Mr. Eugene Tan has asked whether it could have been possible to just amend existing laws. Madam, we did consider this option, but the intent and provisions in existing laws are worded generally to deal with broad law and order situations. And in the end, we felt it was preferable to propose a dedicated, temporary piece of legislation to meet the specific policing needs of Little India and adapting provisions in other legislation where relevant. Some members have asked about the timing of this bill. Why can't we wait for the COI? And some have characterized this as a knee-jerk and a hurried response. It's hardly the case. This is not a case of mindless efficiency. This is a case of a targeted and necessary response to a clear and present need on the ground. Madam Speaker, it seems to me we have three choices. One, we continue with the current arrangements with all its powers under POPA. And the question that we have to ask ourselves is, what precedent does it set to use such pieces of legislation with extreme powers for a situation like this? And what sort of risks does that pose? Another alternative is to revert to status quo ex ante, that is, what we had before the riot. And I think members would agree that that would not be satisfactory. And the third option is in the form of the current bill, to have a specific set of powers scoped for the situation for a limited period of time so that the police can continue to maintain law and order in Little India. Are the police powers provided in this bill unprecedented? All powers, specifically police powers in this bill, are already available under POPA, which has been invoked on a weekly basis since 8 December 2013. In drafting the bill, the specific powers of search and seizure, for example, take reference from similar provisions in the Public Order Act governing special large-scale events like National Day Parade. I agree with members that investing such powers in our officers, we must ensure that they exercise them with sensitivity, with prudence, and with care. That is the training and the culture in the police force and in our other enforcement agencies, but it's a point that is worth repeating and emphasizing. The main exception in these powers pertains to the provisions with respect to alcohol-related measures. There has been a comment that this appears to be a bill that is focused or appears to be alcohol-centric. And there's a good reason for it. This is because we do not have provisions in our laws for such measures. Some have asked, are we jumping the gun? Where is the evidence or causality that directly links alcohol consumption to this incident? Well, Madam, I would say that our police officers on the ground do not have the luxury of contemplating a variety of options when there's a clear and present danger and need on the ground. They have to make a reasonable operational assessment of the situation and what could be the range of contributory factors. And these then have to be acted upon. And one of them, in this instance, was the assessment that alcohol could have been a contributory factor. Now, this is not to say that this is the primary cause or that somehow we have committed to a specific attribution for this incident, positive attribution for this incident. Indeed, this operational assessment of the police is not unique. You have heard other members of this House speak on the matter, and it's a view shared by residents and other stakeholders and businesses in the area. So this bill introduces, out of necessity, targeted and temporary powers to restrict the sale, supply, and consumption of alcohol. And many of the provisions provide clarity on the operation of this framework. It may have created the impression that this bill is alcohol-centric, but that should not be the case because this bill also serves other public order imperatives. This includes dealing with non-alcohol related threats such as prohibited items and disorderly conduct. Several members have also asked whether this bill, in the way it is designed, and its geographic limitation to Little India, is somehow discriminatory or targets a particular community. Madam, first, to be clear, these measures are specifically put up to maintain public order in Little India in the aftermath of a serious incident. We have not imposed similar restrictions in other areas of Singapore or sought to do so because we want to be targeted and proportionate in response. So I want to assure several members like Ms. Fu and Mr. Dinagaran that our enforcement agencies like the police and NEA continue to keep a watchful eye on other areas, and they have also increased the surveillance and monitoring to manage any disamenities and enforce law and order where necessary. So whilst this bill focuses on the situation in Little India, other efforts are afoot. But is this targeting a particular community or does it have a discriminatory impact? I understand the sentiment that's expressed by some, but I want to assure all members that these concerns are wholly unfounded. And indeed, it's a point that was made by Ms. Ellen Lee. The bill is focused on Little India because that is where the riot occurred on 8 December 2013, with inevitable lingering security concerns. And in fact, we continue to have large gatherings there on weekends. So we need measures to ensure that public order and calm is maintained at that location. And I would venture that if in fact this bill had been cast more widely, reaching into other parts of Singapore, as some members have suggested, it would have elicited a counter-criticism or accusation that it is overreaching. Where is the justification? Moreover, the provisions in the bill are targeted at behavior that threatens public order and not at specific individuals, communities, or businesses. The measures apply equally to all persons and business operators within the special zone without exception, whatever their ethnicity, whatever their nationality. Neither is the bill a comment on the conduct of foreign workers or how they behave in Little India per se. The vast majority of foreign workers are law-abiding. We have said this, and I have said this many times. They are here to earn an honest living and build a better life for their families back home. The measures being taken to maintain law and order in Little India will, in fact, serve their interests as much as the interests of any others who visit the area. I now come to the specific powers. Mr. Vikram Nair asked for a clarification on the intended purpose of the inspections under Clause 9. Clause 9 is adopted from the special event provisions in the Public Order Act, and it has the following uses. First, It is used to ascertain whether a person has attempted to bring in a prohibited item into the special zone. Second, where the subject is suspected of consuming alcohol in breach of the prohibition and has hidden the alcohol, the officer may examine him and his property for any incriminating evidence. In other words, acting on reasonable suspicion. And third, where the subject is not suspected of consuming alcohol, but an inspection reveals him to be in possession of alcohol after permitted hours of sale, the officer can ask the person to reveal who sold the alcohol to him for the purposes of investigation as to whether the sale was unlawful. Clause 9 does not and is not intended to penalize mere possession of alcohol. And I do not think that it would be reasonably necessary for an ordinary shopper doing his weekend shopping at Mustafa, although I'm told Mustafa does not sell anything alcoholic, and carrying his purchase of alcohol to be made subject to such an inspection if there are no other accompanying circumstances indicating a possible contravention of the bill.